Good morning, one and all. I, Ms. Purva Narvekar, feel honored and obliged to take this opportunity on behalf of Thakur RAMNARAYAN College of Law's Placement Cell to introduce to you all our resource person for today's webinar on the topic Experience of Virtual Court and its Pros and Cons. Advocate Rajdeep Lahiri sir is an advocate and counsel representing before the courts and tribunals at Bombay, New Delhi, and Kolkata. Sir leads a team of young and dynamic professionals into various domains of law. Sir is the founder of Vakeel Mitra, a legal aid organization based out of Mumbai, which is into pro bono legal assistance for the poor litigants. I also take the privilege of introducing Advocate Jamshed Mistry, sir. Sir is an experienced counsel with demonstrated history of working in the law practice industry. Sir is skilled in various types of litigation, international law, public interest causes, service laws, etc. Sir is the founder of internationallegalalliance.com. Sir is an associate member of the Canadian Bar Association, advisory board member of the Vancouver-based South Asian Fashion Week, member of the Indo-Canadian Business Chamber, Indian Merchants Chamber, and much more. The pleasure is all ours to have you both with us today. Without any further delay, I would like to request our resource persons for today's webinar to begin with the webinar. Over to you, Rajdeep sir.
With permission from Jamshed sir, I'll commence on this very intricate and a very important topic, digital courts. Of course, with all due respect, we are all have our own opinions about the impact, pros and cons, advantage, disadvantage, and what's in store of this entire saga of digital courts and the future. But I think before we delve into our opinions and of course the opinions of the viewers and the students, professionals alike, I think we must delve into what has actually transpired over the last many years. I will not say few years, but many years, which has led to the coming of today's age and which will lead the coming of the tomorrow's episodes or stories and opinions, which we will of course be discussing. And of course, I've been reading various reports, and of course, these have happened much before we were in the profession, or even before we were born. And so we'll have to understand as to the nature and the entire background which has led to of course the huge influx of information technology into this vast country of an immense population, of a diverse population. And we've always heard of this saying that India is always behind in information technology than the other Western cultures. We'll have to understand the reasons behind it. So, in fact, we are talking during the independence time. Of course, there are various reports which says, and this I'm strictly not speaking on the influx of computers into the judiciary or influx of computers in law. It is because of the fact that at that point of time, and this I'm talking of the 1950s, 1960s, in fact, in that point of time, India had one of the largest populations and one of the largest English speaking populations. And that's really the turning point, apart from the fact that there were various executive policy, legislative motions that were passed, like the automation of the entire employment sector in the 1970s, etc. But really, the first turning point, apart from the fact that the first computers were first given to the Indian Statistical Institute in Calcutta, the first supercomputers of that kind, because very few people at that point of time really knew how to operate the entire system. But the fact that the India had produced such a large number of English-speaking graduates led to the fact that India was a perfect marketplace for the Western cultures and the Western companies to come inside this country and to have their operations based in this country, which in fact led to the fact that India actually needed a system, an automated system, a system which would make everything very easy. And at that point of time, of course, Jamshed sir will be can elucidate it much clarity. But at that point of time, I think the Supreme Courts and much of the other courts were operating without computers, and there used to be long lines by interns, law clerks, and the associates of law firms and the senior counsels to check the boards. There were typewriters being used. Dictation used to be on handwritten notes. And it was a system. It was not a very difficult system at that point of time because nobody had the experience of using computers. But the influx of computers really started in the judiciary in 1990s when the Supreme Court really felt that there is an urgent need for some sort of automation into this entire aspect of delivery of justice, and especially delivery of justice by the Supreme Court and the High Courts in India. And then later on, we've seen, especially in 2002, 2003, we've seen that there were not really a lot of provisions. There were not really a lot of clauses, not a lot of support, which the litigants or the advocates or the professionals could take from the acts that were there. The Indian Evidence Act really lacked, in that sense, the presence of any form of acceptance of electronic evidence. But that really changed by the Bombay High Court when, for the first time in 2003, where video conferencing was accepted. Um, video conferencing, sorry, video conferencing was accepted for the first time, and that actually led to consequential changes in the Evidence Act. I feel that there were various turning points. In fact, there were a lot of pressure in the 1950s, 60s, 70s, even in the 80s, by the government in an attempt, because they were seeing what the Western cultures were up to, how the Western cultures were operating their systems, and taking cue from the operational capabilities that the Western cultures were exercising at that point of time. That really took cue, and they were formidable. If you see the history of the parliamentary motions, you'll see in the 1970s, 80s, they were really violent. They were violently fought, the motions for automation, especially in the employment sector, and the influx of information technology slowly crept inside every sector. But eventually, in the 1990s, the Supreme Court took cue, which led to the fact to leading a very robust and a comprehensive report being filed in 2005 by the Supreme Court, which entailed really all the necessary details which was really required to be followed by, especially by the Supreme Court and the High Courts, because the theory of inclusivity was, of course, there, but was not really prevalent in its in the sense that in its execution of the plans that were entailed in the robust system, or in the robust report that was set, was not really executed in that sense, in a very good fashion, in a very structured manner. So I think I'll pause here. With that being in the backdrop, I'll request Jamshed sir to please continue from you. Jamshed sir. Okay, I think till the time he's back, so I'll continue for a while. Jamshed sir, please, whenever you're back, please just give me a ping. Okay, so till the time he's back, and we're all very new with technology. Okay. So that was the backdrop, and I think that, of course, in fact, I was reading a very important report by the Vithi Legal and of various other reports that was published in the official government websites. So they were always speaking on various flashpoints in the Indian tryst with technology, especially in law. And this, I'm not looking at law. Computers is something which aids in every sector, which aids every profession. In fact, there are various practitioners of law which base their entire practice only in the laptops or in the confines of their house or room or office. And okay, so Jamshed sir is on. So I think before I pause here once again, I will say that with this being kept in the backdrop, computers right from the 1950s when the first installation happened, it has crept inside every domain, every domain of the profession, and it was the power of the legislature that brought this into effect. And Jamshed sir. Jamshed sir is online. You just wait for one moment. Okay. Okay. So I think again, once again, so till the time Jamshed sir comes, let me put a little more details to all of you all. When we are speaking on, of course, we are speaking digital age, digital computers, video conferencing, we're talking WebEx, we're talking Zoom, we're talking GoToWebinars. It is very important because as lawyers and as professionals, we always back our arguments basis of precedents, case laws, what has happened, what has transpired, whether there is a settled position of law. In various webinars which I do, which I undertake, which I give, I always see that what was the data, what had happened then, what was the situation at that point of time which led to the coming of today's present era, present situation. And that is something which is very important, which will lead us to talk as to the present situation, and which will again enable us to give us some opinion on what will happen tomorrow and all the practical aspects. We when of course till even till a few months back, till at least last year, this entire idea of video conferencing was a very draconian idea, and there are various judgments passed on that effect, especially in bail, anticipatory bail, especially of matters where the litigants were incarcerated for a long time and they were unable to even file wakalatamas, etc. And that I think Jamshed, I'll leave that with Jamshed sir to speak with more clarity on that. I think Jamshed sir has joined in. He was, I think he'll be here. Yeah. So there's some, I think, work issues. Of course, it is brilliant. Why? Because I think, in fact, few months back there was a note, there was in fact, a paper cutting which I read saying that internet services may be hit because of the fact that everybody's at home, everybody wants to access the internet, and they've actually decreased the quality. So I don't think there's any HDR quality or something like that, which will of course enable to ease the dissipation of internet services to everybody who's willing to access that. Just wait for Jamshed sir to come in. So can I speak? This is between you and me. So I think let him come till the time. Let me speak then. Okay. So so of course I'll take this forward again with an implied consent of Jamshed sir till the time he's back. So this being the backdrop with digital courts, and of course Jamshed sir is of course the right person. He's been fighting tooth and nail with every authority on the introduction. So his fight was on the introduction of legal transcription in the courts and tribunals in India. Of course, taking cue because he's also a counselor and an attorney in the courts and tribunals of Canada. He's of the Canadian Bar Association, as was duly introduced at the very preface of today's webinar. And taking cue, and we, of course, taking cue from professionals, from hardcore professionals like Jamshed sir. They have experience, they have seen how the legal fraternity, how the courts really function in Western culture, in the other cultures, and not only the Western culture. We've seen a fantastic system which is in place and working in Singapore, in Japan, in Thailand, because now we have the Thailand Arbitration Center, the THAC, which has a fully functional office for arbitration matters, cross-country arbitration matters, where you really want to seek to be in Thailand, etc. And everything is done through video conferencing. In various other webinars, I've spoken with attorneys who are not based in the country, but maybe the arbitration is based out of Bombay or in New Delhi, etc. But the attorneys are present in different parts of the world. So that is the beauty of this entire system of technology, of the technology of video conferencing. Remember, video conferencing was always there. The theory of video conferencing now has a very new meaning. So with that being said, let me talk something on what's happening at the present situation. COVID started in the month of March. Officially, unofficially, it started way back in 2019 November, when we started getting reports on China, etc. But in India, due to XYZ reasons, the entire motion of lockdown, etc., started in the month of March to 2020. We are in June 2020. Before that, we've always heard, and of course, there are various judgments. So some of the judgments I'll speak on, we've all heard of the 2003 judgment, 2003 judgment, where the Bombay High Court had passed, and a historic order in that sense, where video conferencing was duly accepted as a measure for the influx of technology. Number one, for the influx of technology for the first time in a big way inside the provisions of the criminal procedure code. And number two, it enabled an easy movement and ease of access to justice for litigants. So video conferencing in the sense had always been there. Of course, now it has taken a very new leap, it has taken a new meaning, it has taken a new interpretation, a new importance. In the sense, number one, it is litigant friendly. We sometimes forget that as professionals, but the first priority and the foremost importance must first be given to litigants, not the professionals, unfortunately. So ease of access to justice should be the first priority, because of which video conferencing measures and electronic filing of petitions. In fact, I did a electronic filing day before at about 1:30 a.m., which led to the matters being listed from time to time. So electronic filings, dispensation of verification, making affidavits in light of COVID-19 situation. So these are all measures, these are all the assistance, aid and assistance which we are getting from time to time through the mode of technology in law. We've also seen the formation of the E-Committee. Of course, E-Committee was always formed. We've seen the robust report which was drafted very carefully with the theory of inclusivity, with all the mechanisms in place, the modes, the procedures that is to be followed by all the litigants, judges, professionals alike in 2005, but that really was not that was not really acted upon. I will not go into the veracity of the reasons why it was not acted upon. Be that as it may, so till that time, uh, we've also seen in divorce matters, especially in mutual divorce by mutual consent. There has been orders passed in Bombay by the Bombay High Court, which dispenses the personal appearance, which dispenses the personal appearance of the litigants. There has to be certain parameters set from appearing before the court at the time of filing of the first motion and the second motion, if you know what I'm talking about, in filing the 13B motions, 13B petitions in divorce cases. There has been orders passed. So in that sense, Bombay High Court, to that and to some extent, the Delhi High Court has been leading the forefront in delivery of justice, in the ease of access to justice by the proper and on-point use of technology. Let us not forget technology, of course, it has its advantages, it also has its disadvantages. Of course, like the like the problem we are facing right now, network issues, inclusivity is another very major issue. Economics, I would say, is another very major issue. Why economics? Not every advocate, we are of course sitting from the comforts of our home. We have systems in place, we have 2 3 systems in place where we are accessing, we are seeing this webinar from a mobile phone, we have a laptop which is open on either side of the systems, and we are accessing justice in the clearest form of definition that we can. But the Supreme Court, especially His Honorable Justice Chandrachud, has also stated in clear terms that apart from the fact that physical courts is also needed, but cannot be done in light of the present situation, but there has to be, I stress, has to be the notion of inclusivity. All the access of justice must be made easy, if not free, easy and convenient to all the advocates who are present in the entire country of India. All the litigants who knock the doors of the court must have access to this kind of technology that we are having. If Cisco WebEx is unable to, is unable to provide access, is unable to give the convenient access to all the litigants, even the poorest of the poor litigants who are fighting their cases as a way of first appeal or second appeals, who are fighting their cases in the labor commissions outside Bombay, somewhere in the towns and the panchayats, etc. The Supreme Court has said, and of course this we have seen by precedents, that the reports and their entire notion of delivery of justice today, the use of technology will fall flat. We have seen by the reports that have been filed and the robust, comprehensive reports that the Supreme Court or the legislative bodies deliver from time to time. In some way or the other, they are always aiding the higher courts. The Supreme Court, with due respect, has taken cue of this and said that the reports must first, and on a priority basis, must aid the trial courts, not the lower court, the trial courts. I consider lower courts to be the trial courts. We're talking of the metropolitan courts, we are talking of the JMFCs, we are talking of the commissions that are formed for the dispensation of justice in various domains of law, be it the employment sector, be it the labor sector, etc. So it is very important to have the theory of inclusivity, which right now I think is happening in a very big way. I come from Calcutta. I've spoken with my colleagues, friends, litigants, and the various other stakeholders who visit, who practice the profession of law, and the other professionals who appeared before these tribunals, commissions, courts in various parts of West Bengal, Jharkhand, Orissa, Assam. And there are various mechanisms taking cue from the report from the directives of the Honorable Supreme Court to introduce technology in their courts, to introduce the use of various platforms like video, Cisco, GoToWebinar, we have Zoom, because there are various reports coming out of Zoom. But be that as it may, the use of various platforms and the use of technology for eventually helping the litigants for the access of justice. I'll once again call upon Jamshed sir if he's able to hear, and if he can aid me in putting a more clearer picture. I'm sorry, I was talking about disadvantages of technology. Anyway, so again, once again, Jamshed sir, so you can just just let me know whenever you are able to hear me or see me, etc. Okay, so again, the present situation, we have the reports being filed by the Supreme Court of
Can
India.
you hear me
We
now?
have okay, so Jamshed sir is here. Thank you.
Yeah, is this better?
Thank you, sir. Welcome.
Thank you, thank you. Sorry about you're talking about technology, but I think this is
No problem.
learning. Okay, well, I've only picked up a few things while we were trying to. So yes, so good morning to all. Sorry about this. Uh, I think Rajdeep has spoken in great depth about sort of the past, and he's now come to the present. I'll quickly go to the past for other reasons. I think you know we're now getting into a space where we are saying, there was an interesting phrase that you learned in sociology saying man is a social animal. Now we are moving to a phase where we say man is now a virtual animal. And I think the way in which, sort of coupled with the fact that we have a pandemic, which is hopefully should get over more sooner than later, the, the difficulty is that we have to look at technology, digitalization as a judicial reform. If and as Rajiv very rightly said in the past, you had a system in place. Yeah, I mean, and I always give this example that first you had the you had, say, the telegram, then you had the telephone, which is the landline, then you slowly moved to the pager. I remember when we started practice, it was the pager, and then you moved to the mobile phone, and now you have satellite phones, and maybe tomorrow artificial intelligence, where you can actually know what I'm thinking. So I think we've seen this move over a period of time. I would like to take this in the context of a subject that I am very passionate about, and that is transparency. And if one thing that we've always remembered that we've never had in our courts, although we say that we have an open court system, complete justice, etc. Uh, Something that was started and was part of the common law system was what is known as known as transcription. Now, this is something that I learned when I was, practicing law and doing a few cases in Canada. And I suddenly realized that after I finished my arguments at the end of the day, I received an entire uh, transcript, which is actually audio, which is, a conversion of speech to text. And at the end of the day, we found this entire, like what I have said just now was recorded and was presented to me in a particular format. Now, this enabled me as a lawyer to go back and look at it and say that, this is what I argued in court today. Now, if we go back in time, you will be amazed. And I tried to, research and find out whether we had transcription because we were a part of the common law system. And I found that this was actually available. And in fact, I asked Mr. Jaikar, who had, curated the museum for both the Supreme Court and the Bombay High Court. I said, have you been able to find this in its use in the Bombay High Court or anywhere else? Earlier, it used to be called the Supreme Court of Bombay. So he said, no, I have not found anything yet. And I think I got inspiration after passing by the courtroom number 46, which is our central courtroom, which has, the court where Tilak's judgment was finally delivered. And I decided to do research, and I found that in 1908, after passing the judgment, Justice Davar, as he then was, I found that after, from paragraph 27 of that judgment, everything that you said, or rather was said in court, was actually transcribed. Now, please remember, there was no computerization, there was no electronics. How did they do that? So we went back and we researched even further. And I found that, in fact, they used stenographers. This was the same process that they used for our legislature. And in fact, you'll be amazed to know that whether it was the Parliament, Legislative Assembly, or Municipal Council, they used to use stenographers and change them every 15, 20 minutes sometimes, so that they maintained accuracy. So if you notice today, all our parliamentary proceeding, every single word is recorded. I mean, even whether people behave themselves or not behave themselves in parliament. So, but the fact is that every word is recorded. Now, as you know, which is now a famous judgment in Swapnil Tripathi's case, several persons, filed asking for live streaming of proceedings in the Supreme Court, starting with the Supreme Court actually, and we intervened. In fact, a client of mine, he had lived in the West, and he knew what transcription was, and he said we must get this in our system as well. So I appeared in the case, and we supported live streaming, of course, and in that we were able to point out to the court that this is one of the most simplest way or the first step towards complete openness and transparency in court, and that it would lead to the advent of of course digitalization, but the fact that you can then go virtual with a system like that. Now, of course, the court, and if you read that judgment, it sort of not only accepts the fact that live streaming based on certain principles should be allowed, but after that, it also says that you have to take into account and bring in transcription. Now, unfortunately, for the last 2 years, right up till now, that pilot project of live streaming did not happen, and that is I think one of the reasons why when we suddenly had the pandemic, uh, you know nobody was really uh, sort of accustomed, except for say lawyers who were doing conferences, and especially those who were non-litigant litigation lawyers who were having video conferences, etc. So they were used to it, but others, right from the judiciary to the lawyers to even litigants per se, there were no set guidelines, etc. Now I think as we are moving forward, we have, as Rajdeep said, the E-committee, the Supreme Court is leading the way. I think all those guidelines are in place. I think several, technology platforms have been uh, engaged by the committees of the Supreme Court to ensure that it is done in a systematic manner. So this is where we are from as far as the past is concerned. Yeah, Rajdeep, carry on.
Sir, the E committee, the report, the recent report, and the Supreme Court leading the charge, which leads to the various high courts and the district courts and even the trial courts taking cue from that and having their own platforms in place, and eventually aiding the litigants. So I stressed on the word that access to justice must first, the theory of inclusivity for all the litigants and professionals alike. So even in the distinct courts, they have taken cue from the recent E-committee report, which of course Justice Chandrachud had even, by a webinar had instructed and given a clear directive. So we've spoken on that too. So that is the present, and of course, everybody's really keen on speaking the advantages. Of course, there are disadvantages too, but I think we must bear in our minds that this is here to stay. And physical courts will, of course, in the times to come, will start, but digital courts are here to stay, and of course, we must have opinions and various other strategies, any other observation which can help in making the system a better place. Of course, so the government and the judiciary is, of course, inviting that too. And this is something which I've also heard, that the Bombay High Court are also inviting tenders for various information technology companies to come out with their own platforms, a customized platform for making the entire digital courts a very realistic affair.
So I think, yes. So I think, see, if you look at the advantages of, so so basically what Rajdeep said is there are two types. One is where the entire court system is totally online, and the second aspect is the hybrid system. Now, I think what currently uh, you know, our system is grappling with is you have to first bring everybody on board, then introduce a complete online for a complete online system. But I think before that, I think what and there have been sort of and I can imagine that for 100 years you've had a court system which has been completely physical. So that's why people will take time to adjust, and as a result, I think one of the let's take an example. If And I think that is pretty much where we are going to go in the near term. We are going to have a system by which you have, uh, and I always give this example of a television studio. In a television studio, somebody reaches the studio, excellent, no problem. Similarly, somebody reaches the court. Somebody cannot reach the court. Then what happens? Then or a television studio. So then you have what is known as a video wall, and you have people joining in from there. Now, today, for your 9, 10 o'clock regularly on television, what you watch, everybody is used to. You don't have 50 people sitting or 20 people sitting in the studio. You have people joining in through video wall. And now that is normal, it is accepted. Similarly, I think even in courts, we are going to get used to the fact that I'll be very happy to put on my computer, argue something in the Supreme Court, switch it off, get on to maybe a Patna High Court, maybe a tribunal, and switch it off, have my lunch, relax in the afternoon, go down for a walk. Maybe that's an interesting way of doing these things. And I think that is pretty much what we're going to see in the near term. But we also have to say that there are fantastic systems that are available in other countries where you have an entire court system which has gone digital, which is, we have civil proceedings. Criminal, there were some issues about, how to, the veracity of a witness, to his demeanor, etc. They said, yes, it is possible. You can have a 360-degree camera. I was speaking to a lawyer in Scotland. He said it's working very, very well for them. And of course, they've introduced it for motor accident claim tribunal. I always give the example of when somebody was caught at 2 a.m., jumping a signal. The police car, came, stopped this particular gentleman, and he put on his television or his screen in the car, and he offered the errant driver the option of seeking what is known as tele bail. So so bail was offered at 2 a.m. to someone, on the road. I mean, so there are sort of very interesting innovations within the system that you can evolve with, virtual technology. So I think we are going there. A lot has been achieved. I think the other thing that we should talk about, Rajdeep, is ADR, or what is now known as ODR, online dispute resolution.
And of course, ODR and online dispute resolution was something which was again prevalent, not in India, but in various other Western cultures, and it was functioning fantastic. So SIAC, and in fact the THAC, their entire systems is completely online. But I think before we talk on that, so we were talking about the advantages of technology. We all know the disadvantages: economic, inclusivity, access, etc. But I think what we are missing out, which I think they are vital for understanding as to a very fantastic age that we are in. And of course, I am very excited of my age. I'm very excited that we are suddenly, there's an extreme step because of an unknown reason, because of some reason beyond our control, that we are into a very fantastic modern age. And I think it will help in certain very important things. It will help to a very great extent in eliminating corruption, because there is a complete openness. And of course, this again, I'm taking cue from your case, from your argument, from your stance, that video of live streaming legal transcription, that again is consequent to the fact that it will lead to an eventual lessening of the burden of cases, pendency of cases. So if you have live streaming, you have something which you are just seeing. You are hearing what has been argued top to bottom. And of course, we've discussed that there sometimes there are advocates who speak beyond what is pleaded, and then they take an eventual turn, and then they say, no, this was not pleaded anywhere. We've seen those stances taken in courts day in and day out. So they argue beyond what is pled, and in the heat of the moment, in the next day, they say that no, this was not argued. So that's re-arguing, and then creates a lot of hodgepodge. There's the burden of cases increases. And one more thing, uh, this is something which, this is just my opinion, it blurs the system of class within a class, where you want to engage somebody who's a case which is going on in Calcutta, and you want to again engage somebody who's in Bombay or Gujarat. You are first lessening the cost, because everything is online. You can engage a counsel who's present in Bombay, who's sitting in Bombay or in Gujarat, etc. And this system of the senior, junior, etc., in a digital world, it blurs to a certain extent. So this entire theory of class within a class, of course, I consider to be an imperial India system. So that gets eliminated to a very great extent. It gives an easy choice for the litigants of whom to approach for representation. I think it also breaks barriers. It is helping breaking barriers in territory wise. It helps breaking barriers in gender wise also. So there are various in this is something which I've read a report on, saying that there are various reasons because of which women, especially women, are unable to go to far off courts, etc. But with technology in place, you're breaking that barrier. It will be easy for a person who's unable to travel great distances but wants to travel. So that access is given. Sir, you took an example of telebail. So I'll take an Indian example of a tweeted complaint. So for making an official complaint with the BMC, you had to traverse the entire process. But now, and this I say by experience because there was a complaint made against my society a few days back for good reasons. But so that was made on Twitter. So again, we are going into technology, modern technology, and this is how it is helping. And this is the importance which we sometimes forget. And so, speaking on online dispute resolution, it's a very burning, not an issue, but it's a very exciting news. Of course, there are arbitrations that are happening by the arbitrators in Bombay, where everything is online, and disputes are being adjudicated, resolved online. And of course, there's a lot of mediation that is also going, which is online. So it's helping the domains of law which was obsolete for quite some time, till some time back, but I think it's reactivated in that sense.
So I'll touch upon all three what you've said. One is, of course, uh, yes, I think you're absolutely right. I think uh, the the class within the class will hopefully disappear, and then like the US, we'll have just one class of lawyers, all equal, all virtual. I think that's something to look forward to. I think uh, uh, the uh, the other aspect, since there are students also, I would definitely request you to please take a look at the International Court of Justice website. I mean, it's absolutely amazing. We did see in the Kulbhushan and Jadhav case, and I followed that for a particular reason. I said, how does the system function? And it's amazing. The day's proceedings are instantly transcribed, instantly put up. The video of the entire proceedings is put up at the end of the day, or latest by the next day. You can uh, go on to that particular, the case law that you are looking for, and you can not only every day's proceedings, all the applications, the plaint, the written submissions, every single thing is there on the site. The other thing that they have, including in the the Court of Appeal in the UK, is another very interesting aspect where the court actually summarizes what it has said and puts up uh, you know uh, basically a summary for the media. That is another important aspect. Very often, and we see this time and time again, that media reports cases for a variety of reasons, not exactly and accurately of what has transpired in court. I mean, I know a particular case that I've taken up at one point of time, and it was reported diametrically opposite. So I asked the journalist, I said, were you present in court? So she said, no. So I said, then, I mean, what you put out is incorrect. I think all that will change if a this the systems are clear. I believe. I mean, this is again uh, interesting update that we got from a member of the committee, that what they're going to do is try and ensure that law colleges will be there will be a link that law colleges will be provided once the system is put in place, so that instead of you going to for a court visit, you can actually put it on and watch it as part of your curriculum. I mean, that is a very important thing. Also, I think moot courts need to change. Law students now should really get used to the fact that you're going to get recorded in future. And so the way you present it, I absolutely agree with you that timelines are vital. If you see the way courts function abroad, you are given say 15 minutes, 20 minutes, and you see barristers profusely apologizing if they go 1 minute over time. So I think all these, the norms, the way in which Even even I think the way we may have to get rid of our gowns and be very happy wearing bands and a coat because that's more comfortable, or even maybe a tie. I think so. So all that is great. ODR, which is another very interesting. I mean, there again, everything from the time that electronically a notice is issued to the various parties to the submissions, the minutes. Say, for example, suppose if this was a hearing, the minute it's over, it's uploaded online, and and even cross examination, it's fantastic the way technology has made and can you imagine, you're sitting anywhere in the world, okay, your say your counsel or your barrister or whoever is pretty much around the world. It doesn't matter which whether you're following the Indian arbitration system or you're following some institutional arbitration system. It doesn't matter. And and as Rajiv very rightly said, the cost will come down by, I would say, in certain cases, maybe down to even 15% of what you are spending today. So I think these are great steps in the right direction. The other thing that we are going to see is the increase, and a lot of money has been now pumped in by international law firms on artificial intelligence. That's the other thing. I mean, I personally don't think because we as lawyers, we always, with the human element, we'll always be thinking, but uh, in certain circles there is a sort of an alarm that has been raised that artificial intelligence will take over mundane systems in the legal profession. So it's interesting. We'll see. We'll have to. The important, my important, the important sort of message that we really want to give is that doesn't matter where you are in. Please, the least that you need to do is invest in a good phone or a laptop, because that is now for a good amount of time that's going to be your office. So the whole system has changed. You can save on rent, but you please invest in a good laptop. I think that's really what we want to say.
In fact, sir, I will just, it's a small point. You spoke on cross examination. I think introduction of technology in a good way will eventually lead to the proper adjudication of justice. Because what the system is now, you ask a question, he answers, then there's a writing done, then there's a correction done, then maybe an argument done on that, then there's a clarification issued. Then we come to the next question. By that time, he's already made up his mind. But then that is not what, in essence, I do not know if that is cross examination in the proper essence. But if you see in the other systems, it is just recorded and you just say. So everything, truth must come out at the first instance.
Yes. And you're right. In fact, in several, I mean, I've seen it in international arbitration where there is live transcription, and that's why what happens is you can change it instantly. And you are right. That saves a lot of time. The chances for applications and review, and I didn't say this and didn't say that. All that it'll just make the process far more smoother. I think your 120 pages petitions will come down to maybe 5 or 6 pages now.
Absolutely, sir. In fact, the tribunals are now insisting. So the NCLAT now insists that no matter how big your pages, your written submissions will only be 2 pages. You argue, it will be 1 page. so,
Absolutely.
so in fact, I say this taking from the cue that if there is a discrepancy in the corroborative material, especially in criminal matters, between your statement made before the police and then you say something on oath before the, why not in cross examination take you from the fact that he's trying to fumble or he's trying to change his statement, which we don't see in the normal course of time, in the normal course of procedure. So you ask one question, then it takes time, then maybe it's adjourned, etc. And this is a faster process, and then proper adjudication of justice. So I think that's one thing. And sir, you spoke on AI. I think AI is already there. We've seen Google already trying to anticipate our needs. If we make a, if we don't type the entire in the search box, we don't type the entire sentence, but it anticipates. So AI is there. So I think Amarchand has already introduced AI. I think AI will be there when there are cases where it can be adjudicated only in filling up of certain parameters. So in cases where by only filling of certain parameters, so I think AI can adjudicate those kind of cases, especially in motor accident claim cases or etc. Something like that. So I don't say much on that.
So I think we've, or rather, you have consumed an hour. Maybe we should now take
Right.
questions,
No,
if any.
I think let's leave it for questions, if any there is. So Ankush, if you're hearing us, we leave the platform open for any questions if there is any. Yeah, they can speak directly to us. I don't, sir, Jamshed sir, I don't think we'll have any problem if they can speak directly.
Sure, no problem.
Um, Hello, sirs. Sir, so the first question for today is, what are the challenges that come up in collection and studying evidences while using virtual courts?
Collection of evidences.
And studying evidences.
So Jamshed sir, do you want to take this?
Okay. So the only okay. So two types. One is that when you want to, for example, copies of if you want to confront the witness with certain copies. What happens is usually, I mean, you file an affidavit of evidence and you do sort of mention the documents that you would be relying upon. The only thing is what happens in a case where you have a document which and you want to sort of surprise the witness with. Even I think those are systems have been made in such a way that you can say the original copy is with you. You can send scan copies of that uh, to the tribunal. That's I mean, tribunal in the sense to the judiciary, and then to the witness you can show sort of share the screen and show him or her that particular document. So I think that's fine. The question of the witness's demeanor also plays a very important part, which one sees either in when it is evidence is led through a commission or otherwise. I think it's that has also been sorted out. You have these very powerful 360-degree cameras, which are now which show that he's not been tutored, for example, in a given case, etc. So I think uh, there are solutions to all these issues now.
Sir, the next question was same witnesses' demeanor and false evidences, what you told just now. So, if you want to elaborate on false witnesses.
We all
No,
know.
so sorry, go ahead, Rashid.
So we all know about a very famous 340 applications where there are penal provisions to that, and in fact, of course, confronting any document, as Jamshed sir has rightly said, you can confront a document. But of course, if it's an electronic evidences, you have the provisions in CRPC backed by certificates issued by the competent authority or by way of a statement by the person who's presenting it. But in case if the confrontation is so prima facie invalid or such a false document, or at the very preface of the entire document, then of course there are penal provisions that ensue. We have the perjury application, the application filed under 340. There are penal provisions but that is a very it has to be looked through an hourglass, and there are various parameters that are set. And so, of course, for false witnesses, there's nothing known as a false witness. It's a witness, but then who stated something so grossly incorrect on oath that there are penal provisions that ensue.
Okay, sir. Thank you so much, sir. The next question we have is, how can we ensure accessibility to justice?
I think this is accessibility to justice in two ways. I think both. That question is very well answered by the Supreme Court in Swapnil Tripathi's case, where it says sunshine is the best disinfectant. And I think that is a wonderful phrase that Justice Chandrachud has used, and said that so the entire system then becomes open. There's no question of sort of the court being closed only to, except in few cases where it privacy prevails over everything else, and those are exceptions to the rule. Those are exceptions even today. But interestingly, the minute you go use the use of digitalization comes into place, this aspect is extremely important. And I think we must say that and point out that unfortunately what you are seeing currently in the pandemic is not something that is the perfect system at all, by all means. Okay, during the pandemic, whatever is happening in court is clearly an ad hoc system. The real and the proper system is yet to come in and is yet to be in place, where you have from digital filing right up till live streaming to the fact that whatever you say in court immediately gets put up on the court's website or the cloud. So and that is very, very important. I'll give you a quick example. I mean, we've so many times seen matters where, for example, the counsel has argued something, the court has said something, and what you see in the order is something diametrically opposite. And then that leads to you have to file for reviews, for revision, for appeals, to get that part of it set aside. So none of this can take place if you have digitalization and live streaming and transcription, because it'll show you exactly what has happened. And let's again be honest, this is again not rocket science. This is being practiced day in and day out internationally, and I don't see why we should be left behind.
Okay, sir. Thank you so much, sir. So the next question we have is virtual court defeating the objective of punishment under criminal law?
Rajdeep.
Very uncertain as to what the question is about. So, is virtual court defeating the objective of criminal law? In fact, it is aiding in the dispensation of justice. I would put it in that sense. And defeating the objective of criminal law. I would put in the sense that so criminal law, as in like so in cases of, let's say, murders or theft, burglary, etc. So where if I am the accused in that case and I am incarcerated, I am an under trial. Uh, so we've all heard of that saying that I am innocent unless and until proven guilty, etc. But I am an under trial. I've been denied bail, etc. And so without technology, so it's a very lengthy process for a representation to reach me and reach out to me and signing the competent papers, making out the case, etc. But with technology, of course, we've seen metropolitan magistrates doing jail visits to see uh, uh, the position of the jails, the position of the inmates, etc. and that they sometimes do from the confines of their chambers in the courts itself, where certain times are stipulated for that, where they do jail visits via video conferencing. I have also had the pleasure of visiting the courts in Jammu and Kashmir, where I have seen that party in persons who are incarcerated, who are under trials, are fighting their cases in person from their jails, from the video conferencing systems that have been installed in the lockups, in the jails in Srinagar, and that they are arguing the cases with the judges of the sessions court, high courts, etc. That also I've seen. So in that sense, video conference, virtual courts, again, it is breaking barriers. It is aiding in the dispensation of justice. Otherwise, I ask you, do you have any other choice? You do not have any other choice. So instead of saying that it is defeating, let us understand how it will, aid and assist in the dispensation of on all the branches of law, including the criminal law. And I think
Sure,
it will help.
sir. Sir, the next question is how can we mitigate the threat of identity theft by either party or a third party?
It's a very important question, sir. I had the same. So I leave that to you, sir.
No, no. I identity theft in the sense that that I say uh, I represent as Rajdeep and Rajdeep represents as me. Okay, I think so. There is the very interesting. I think you have face recognition. That's another aspect of technology. Today, you can open your phone with using face technology. So that is also something that is absolutely and it's common now. It's easy. So yes, that could be a great, in future. For example, if you are representing, I mean, can you imagine, say, when you enter a virtual court tomorrow, your entry to that court is through face recognition. I mean, that could be the future. I mean, and it's very, very possible. So, and whoever it is today, with biometrics and other things, it would be, very, very simple to, to be able to find out, in case there is impersonation of any kind. But I always say that human ingenuity is you know always amazing. So you will constantly have the law catching up with people who are trying to do things like that.
But sir, in fact, even when I don't see a difference between an impersonation in the digital court and impersonation in the physical court, sir.
Right.
If you do not know that person, you will not know who is representing whom, right? And I think there will be a greater emphasis on ethics. So much reliance will be made on the counsel who's representing that client.
Correct.
So in fact, today in e-filing, so we are dispensing of with the verification and affidavits, and that they are taking an undertaking by the counsel who's representing that all the facts are true, etc. And you will file this within. So greater emphasis on ethics also, sir. I think.
No. I mean, we have seen, I mean, and that this is open knowledge, that there have been persons who have impersonated themselves as lawyers. Some of them have, gone ahead, argued cases, got good judgments, and then they have found who they are. So now,
Sir,
in such cases, what happens? I mean, can you therefore set aside all those orders? I mean, these are interesting questions for the Bar Council.
Sir, I'll give you a very interesting example, sir. Now, so physical courts are happening in the trial courts in the session in the city civil courts of Bombay, as only in extremely urgent cases. So there is a matter which I'm doing in one of the city civil courts, and they are not letting in any litigant apart from the advocates. So, sir, for litigants, because they have their urge to hear court proceedings of their own matters. So, sir, what they are doing is that they are not saying anything explicitly, but they are wearing white shirts and black pants, and they're just walking past security. So that is not impersonation in that sense, but sir, in spirit, we know what that is. So
I think this is
interesting.
it has always been a serious issue. I think one thing that they now should do is, we all have our, bar council numbers. I think, again for recording, your appearance. Uh, Imagine if, whoever, of course, submits it to the court is fine, but I think the court can instantly, the day is not far where they verify it from the website of the bar council instantly whether you are so and so or not.
So we can
I
have
think
those biometric ID cards also.
yes, that is certainly possible. Yeah.
Any other
So the
questions?
next question we have, yes, sir. The next question that we have is how can we keep our cyberspace secured from the different computer-related data breaches?
So again, so we've seen a lot of so even Vidhi recently has released a very data security research paper, and of course there are various papers bills that have been passed for protection, because I think that is one of the major areas which has led to the people thinking otherwise on the various platforms that are existing right now. We've all heard of what's going on with Zoom, etc., and other applications that is coming from the Republic of China. So that is one of the major reasons of data protection, because as we say that courts, the filings done in courts, they maintain a level of security, and of course the way, so certified copy applications. In case in today, what in nowadays, what's happening in in high courts, especially in the high courts, is that for any third party applications, for any third party who's unknown entity to the to a court proceeding, so they have to file affidavits. There is a hearing done before the registrars. So that is the level that physical courts are playing at for maintaining security of the applications or of the proceedings that is filed in the high courts. Proceedings that are filed via in a digital mode or online, of course, there has to be a robust system. We also have to understand that the influx of technology will also increase the number of manpower, because there are legal transcriptions involved. There's manual typing that is to be done. There's checking that is to be done. There's scanning that is to be done for pending matters. So there's going to be a lot of people who do not have the exposure of working in the judicial in this aspect of profession. And there could be not only digital theft, we're not just talking of data theft, we are talking of theft from the physical courts, from the paper proceedings that is there in person in physical form. So of course there has to be a robust system that is to be there. There has to be stringent procedures. People will have to know that in case you have disregard, in case you do a data theft, this is the punishment. And I feel even if there are punishments, the execution proceedings of those punishments must be very stringent. Sir, if you want to add.
Sure. No, absolutely. And not only stringent, but it should be very swift, and so that to deter people. The other thing is, as I've always said, and Justice Sri Krishna reiterates this very often. He said, we don't have in courts, usually there are no nuclear or other secrets. So where is the problem? So, that we don't have anything to hide. And that I think is also an important aspect when you talk about, cyber security, or I mean, cyber security is, yes, I'm absolutely certain they're taking a lot of steps, and we have great people who are, specially trained for this, whether it is within the ministry or the cyber police, etc. But also, I think we need to, be a little, sort of more open-minded about it and say that, we really don't have anything to hide. So I mean, what advantage will someone get, say, if he or she actually, yes, as in a case where, say, somebody is able to sort of get particular papers and then misuse it, I agree. but otherwise there is no no problem, from stealing from I mean, stealing is a into inverted commas, from a court, because if all your documents etc. are available. Yes, again, for example, say in matrimonial and other cases which are exceptions to the rule, if somebody does it, yes, no doubt about it. I mean, but I think these safeguards are very much on the radar, and I'm absolutely certain, working towards it.
Sure, sir. Sir, now I would like to invite our principal, sir, Dr. A.K. Singh, sir, to speak a few words. Over to you, sir.
Am I audible? Ankush, can you hear me? Jamshed Mistry, sir, I think you recollect me when I was the principal of in charge principal Vicente College of Law for
Yes, yes,
around 7 years. So you were the part and parcel of all the lossless court competition. And Advocate Rajdeep Lahiri, sir, we had a wonderful session for at least 1 hour in our office, and we discussed a lot of issues with respect to legal issues and legal studies. And you have given a lot of insight. And of course, we will just try to associate with you for the benefit of our college. By the way, sir, this is a very wonderful webinar. It is a need of the hour. So, on experience of virtual court and its pros and cons, the two sides of the coin. Of course, it is said that nothing is, everything is rather mixture of black and white. And of course, we as a human being should try to pick up the white part and so far as avoid the black one. And Jamshed sir, you very rightly said that at present what is happening in the code, virtual code, it is just a temporary arrangement just to tackle with this pandemic. But we need to prepare for the future. So I think on behalf of Thakur Educational Trust, Thakur RAMNARAYAN College of Law, the students, teachers, and on my own behalf, I heartfelt gratitude and thanks to both of you, sir. It's really a wonderful experience which you speak about out of your experience. Thank you very much, sir. Looking forward for the further discussion like this. Thanks a lot. Sir. Yes, we are.
Thank you.
Thank you, sir.
Hello, Ankush. Hello. Yeah. So,
Good afternoon, all. I forward my thanks to both the dignitaries for answering all the questions patiently. I'm sure our audience will be enriched with their knowledge through this unique, engaging, and interactive session. We hope to hear again from both of you at different occasions in the future. Thank you, both the dignitaries, on behalf of the audience and Thakur Ramnarayan College of Law. I would like to thank the placement cell at Thakur Ramnarayan College of Law and our principal, Sir Dr. A.K. Singh, sir, for knowing the requirement of the hour and organizing such an informative session for not only the registered participants but for the interested audience also through YouTube Live. I would also like to thank the teaching, non-teaching staff and the webinar team of Thakur Ramnarayan College of Law. Last but not the least, I would like to thank all the enthusiastic as well as patient listeners for making this session successful. Thank you all. Thank you again.